Okay, we'll gavel the Public Safety Committee meeting to order. I apologize for starting 10 minutes late. Covenant House was having an open house. I'd committed to go, so Ms. LaFrance and I walked fast. She was setting a horrible pace, and we got back here just a little bit late. I asked before, because we had some members of the public in the prior homelessness committee who wanted to testify. Only when I did a poll here saw one. We'll have her in. She did ask me to ask you to speak up. She does have hearing issues, but she doesn't think that's really the problem. She thinks we're all mumbling up here, and she may be right. So speak up if you can. We will have presentations today from APD, from Senator Cathino, who's the municipal prosecutor, and Mr. Dunbar has an issue he'd like to bring up that we'll do first. It'll be relatively brief. We also have the fire department who said they are going to give one sentence, and we'll see if he sticks to that. Why don't we do introductions of who is here? Senator Dyson.
Introductions to the
Tell
record.
everybody that you're here. Yeah.
Felix Brad. Christopher Constant here.
John Waddleton.
Eric Croft.
Forrest Dunbar.
Suzanne LaFrance.
Dick Trainee.
Tim Steele.
Pete Peterson.
Seneca Cathino, municipal prosecutor.
Sean Case, Anchorage Police.
Justin Bell, APD.
Dennis LeBlanc, AFD.
Those are up here. We got a kind of big viewing audience, and sometimes we do that. I'm not going to do that unless anyone really wants to announce that they are here. Good.
Amy's on the phone.
Oh, good.
I'm on the phone, Eric.
Oh, good. Sorry, Amy. So just you on the phone?
Yeah, and I'm going to keep it on mute because I'm in my car.
Okay. Be careful, and if you want to say anything, just let us know, and we'll get you in the queue.
Thank you.
That's the call to order and introductions. Mr. Dunbar.
Thank you. I'll keep this just for a couple minutes. I'm doing this now both because I think it's relevant to this committee and because I want to avoid Open Meetings Act violations. I wrote, with the help of a friend, a letter this morning urging our two U.S. senators to vote against Graham Cassidy, the bill to reform health care. And the reason I bring it up here is because massive cuts to Medicaid will lead to less drug treatment and less opioid treatment. And that is something that we know is directly tied to the kind of property crime we are seeing in this city in particular and the state as a whole. So I wrote the letter, and for my colleagues, if you'd like to sign, it'll be after the committee. I'll have it available. That's it. Thank you, Mr. Chair.
You bet. Thank you. Brief as promised. I think we'll go in order. I was thinking about moving it around, but that would be fine. Chief Dahl, the agenda had called for updated data. I think because we had an update from you earlier this month, and you do information monthly, that it'd be fine if we put that off to the beginning of October when you can let us know some real new data. We are going to talk about SB 91 in a moment, and I guess I'd like to give you a chance to respond. We'll go through the details of a resolution we have on it, but you and I conversed by email. The headlines of the Daily News today was that it's hard for APD to nail down the specifics of SB 91's impacts. I guess I'd ask you what you believe from talking to officers or other data you have about what we know about what SB 91 does for law enforcement and whether your department still feels changes are necessary.
Thanks, I appreciate that. And you're right. I know due to scheduling and so forth, this meeting fell a little bit close to the last one, and it's difficult for us to update the kind of stuff we've been showing you on every 2 weeks. So I appreciate that, but we'll have that next month. The discussion that we had earlier today, I think, revolving the article and some of the stuff, I think the main thing is that we do support SB 54. There's some modifications coming to SB 91, or at least being contemplated. we think that that's a good idea. I think that, after SB 91 was implemented, we've seen some things that maybe aren't working out the way that everybody thought they were. Just to be, address some of those unintended consequences. With regards to the way the headline was structured in the paper, I think that, what we're seeing is there is an increase in property crimes, and, we've heard sort of anecdotally that there is an increase in shoplifts as well. That's a little bit more difficult for us to track because some of those things don't get reported to the police department. They get sent directly to the prosecutor's office, and there's some sort of, we would call it diversion programs, just other ways to make sure that those get addressed that make it more difficult for us to look at. But I think overall, it's not news to anybody that we're seeing an increase in property crimes. I think that asking us to directly correlate that to SB 91 becomes a little bit more difficult because, for one, that's only been in effect for a short time period relevant to crime data. And for two, it's just for us to know why particular crimes are occurring can be more difficult to ascertain. So I'm not sure that that's something that we can definitely say. And I think that Captain Case discussed that a little bit in the article. But overall, something we've been talking about for a while now is that, Anchorage is seeing a rise in property crime.
Have your officers, either for Captain Case or for you, Chief, seen situations at retail stores where somebody you cited and SB 91 reduced it to a citation, a trespass, or a shoplifting under 250, and you're seeing the same people repeatedly?
I've heard that. I don't have any kind of specific data type information to say how many of those people there are or how frequent that is, but I have heard from police officers that that's their feeling, is that they see people more than once for the same type of offense.
Appreciate that. If I think what I'd propose to do is have the presentation by the prosecutors, and of course hold on to you guys for further comment afterwards. Would that be appropriate? Ms. Thino, it's good to see you again. I'd propose, and for the members of the committee and any of the public, there are handouts. There are three. A resolution that I drafted and Mr. Trainey and I are going to propose regarding SB 91, the fix, SB 54, and some of the things that we think should be added to that or subtracted from it. So we'd like to have the committee chew on that with us and make sure we're doing the right thing. There's also, secondly, a copy of the Municipality of Anchorage v. Brooks, which is a case that Ms. Thino and Mr. Falsey won before the Court of Appeals interpreting SB 91, and it's relevant to some of the changes we're proposing. And then Mr. Dyson kindly and appropriately distributed a copy of SB 54, which makes some of those changes. At a prior committee meeting, Senator Dyson had tasked me with asking APD and Ms. Thino what is in 54 that you like, what is left out of 54 that you would have wanted, and if true, what is in 54 that you don't like. Sort of, is this the right thing? Is it complete? And is there any aspect of it that bugs you? And that I did that because I do what he tasks me with, and that this resolution then is a draft of that approach. So I'd like Ms. Thino to go through her presentation, and then we will all, with her help, try and understand what we're proposing to ask the legislature to do and not do. Ms. Thino.
Again, my name is Seneca Thino. I'm the municipal prosecutor for the municipality of Anchorage, and I prepared this presentation at the request of Mr. Croft as an overview of what my office is and what we do, so that as we have discussions about changes in SB 91 and changes in criminal laws in general, you'll know what that means for the municipality. So our office handles cases that are referred by primarily APD, so to be able to prosecute misdemeanors to APD. But we also do prosecute cases that are referred by the state of Alaska, which would be the troopers, UAA police, the Marijuana and Alcohol Control Office, airport police, and the railroad. We prosecute a variety of offenses, DUIs, domestic violence, assault, stalking, drugs, weapons, and a huge number of driving offenses as well. These are both violent and non-violent offenses, so there's oftentimes this perception that felony is violent and misdemeanor is non-violent. That is not accurate. Both felonies and misdemeanors have violent offenses and non-violent offenses, and we do both kinds of offenses in our office. We prosecute about 85% of the misdemeanor cases that are heard in the Anchorage District Court. The other 15% are handled by the state of Alaska, the district attorney's office here, and that accounts for about 35% of misdemeanors statewide. Just quick through the numbers, we do court hearings 7 days a week, 365 days a year. We're doing typically at a minimum of 34 hearings a week. And then on top of that will be trials, evidentiary hearings, restitution hearings, any other special hearings. So it's very busy work. We prosecute anywhere between 7,500 and 11,000 plus cases a year. And just as a side note, the number one influencer that changes, whether it's the low number or the high number, is the volume of patrol officers who are out on the streets. That's where our caseload comes from.
Can I ask you on that? So
Yeah.
we're planning on increasing that number. Are you going to have later predictions about what that might do to your caseload, or it's too difficult to predict?
I don't have predictions. What I have are some numbers about what the caseload has looked like over the years, and those can be correlated with the strength of APD's patrol numbers.
Pretty confident that more patrol officers means they're just catching more people doing from everything from driving without a license, which used to be a crime, is now offense, but DUIs, just other stuff.
Yep, exactly. In our office, we do have 14 lawyers. We have 13 staff members and 2 APD officers. Those 2 APD officers are assigned to the warrants department. Their responsibility is to go and check compliance for domestic violence offenders who are out on bail conditions. So they're checking to make sure that they're not having contact with the victim, that they're not in the victim's residence, or whatever other conditions the court has imposed. And that's specifically what they do. Of our 14 lawyers, one of them is housed at the U.S. Attorney's Office, and he is a special assistant U.S. attorney who is prosecuting Anchorage-focused federal felonies, and that is one of our lawyers.
Mr. Trainee had a question. Was it on this?
It's on this, relative to 14 lawyers. The mayor's administration sent out an information memo to the department saying to project cutting 10% back on your budget, 5% public safety. Are you guys looking at doing that, or do you consider yourself public safety a 5% cut or 10% cut? And tell me what that's going to mean to your staff to prosecute. Because if you don't have a lawyer, you're not going to prosecute.
Sure. Well, we certainly consider ourselves public safety. My understanding is that originally we were requested to make a 10% cut. That was reduced to 5%,
Okay.
and then now may actually be even a little lower than that. At the 10% level, it was a cut of 4 lawyers for the Department of Law between prosecution and civil. At the 3%, we believe we're going to be able to get away with not cutting any lawyers at all, just a staff position.
Okay. As we get into the budgetary cycle, I want to keep track of this
Okay.
because I need to know where we're heading with it.
Sure, and I will say
Thank you,
that
Mr. Chairman.
we are 1 lawyer down from where we have been in the past, and we are.
What are your plans to hire that lawyer back?
No, that we gave that position up years ago.
Okay.
And we are staff members down from where we were in the past, and those positions were given up as well. So we do consider ourselves sort of at the bottom level that we can be with the caseload that we're prosecuting. If our caseload goes up, or if we lose attorneys, then our caseload is going to have to reduce.
Well, the chairman's correct. We are adding more police officers. We know what the caseload is going to be. So if that's the intake mechanism, we've got to make sure you're part of public safety, that we don't chop you guys off and still expect you to handle a heavier caseload.
I agree wholeheartedly.
Thank you, Mr. Chairman.
So,
I figured you might. Okay.
Mr. Peters.
thank you, Mr. Chairman. So along those same lines, are we getting people to speedy trials in time so that people aren't just sent back out on the street because we couldn't get them to court within a reasonable amount of time?
Sure. So the speedy trial is a constitutional right that defendants have in Alaska. It's 120 days by statute. We lose probably 5 cases a year on speedy trial issues, and they are almost all warrant issues. And there's legalities related to warrants being served on folks when they're in custody. So we are not losing cases because we're just too busy.
Okay,
Yeah, for that reason.
thank you.
Senator Dyson.
Thank you. what percentage of your cases get plea deals?
I don't know the exact number, that's not a stat we track, but my guess would be, of the cases that we accept and prosecute through to conviction, it's probably in the mid to high 90s, which is pretty standard for prosecuting agencies
On misdemeanors?
on all cases.
Quiet and blinking, 'cause I'm trying to...
We don't know whether that means he has another question or not. I usually give about 30 seconds and then move on.
Senior moment.
Yeah, no. Kind of following up on those two, if it's not speedy trial, if you have that caseload pressure, either because they keep you at the same staff and your cases come in, more cases come in because of more officers or other reasons, or they do reduce you or a combination, how do you handle that? Do you just decline more cases?
Yes. So decline is a specific legal term, it's a term of art. We use it to mean a case is not, we're not going to file charges. So when police officers issue a citation or they make an arrest, that isn't actually the filing of the charge. The filing of the charge is when we submit an information to the court saying these are what the charges are. So when we get the paperwork from APD, we may decline, which just means we're not prosecuting and the case doesn't go anywhere. That's distinct from a dismissal, which is after we have filed charges, the case does exist, and then we go ahead and dismiss it for some evidentiary or other reason. So yes, our decline rate would go up if our staffing levels went down to the point where we couldn't accommodate them.
Yeah, Mr. Ruffin.
Did I miss it? What is the decline rate?
I didn't say it. The decline rate right now is about 24%,
Well,
which is also, there's not, I can't tell you what the standard is. I can tell you that our goal, as long as I've been with the office, has been between 20 and 30% of declines. And those are for evidentiary issues. The case just doesn't look good when we look at it under the light of day. It's not a good use of our resources. We don't think we can prove it beyond a reasonable doubt. Wrong person charged. All of those kinds of reasons will cause declines.
Thank you.
Mr. Constable.
Yeah, thank you. What are the classes of charges that you're declining that you just aren't going to move forward on? Is there kind of a generalized category or categories?
So we evaluate every single case that comes in to make sure that we have probable cause and then to make sure we think we can prove it beyond a reasonable doubt. So we can decline on either of those two issues on any subject matter. We will frequently decline for resource purposes. Frequently the purpose is resources as opposed to we're frequently declining. Our lowest level offenses like disorderly conduct, which is now a 24-hour max sentence. Most of the time, by the time we get the case, they've served that sentence already. We will decline thefts where we don't believe we have sufficient proof. We will decline cases where our witnesses have significant criminal history that makes them an improbable witness for trial purposes. So that runs the gamut of the nature of the offense.
Seneca and I served together as line prosecutors in 2008, 2009, and you have to have she did a very good answer to that, but you have to have a vague answer to that. If you say, we're going to decline anything under 500 that's a shoplifting, you've done kind of what 91 did, which is everybody figures that out after a while and just knows I can steal $300. And so it's got to be, you don't, in that particular case, if you have a rule of thumb in your office, you may not want to be very clear about it to the community. You want to do...
Also, I'm sorry,
Yeah,
apologies
good.
if I may follow up. We may, as a routine matter, decline low-level thefts, but if we see a person who has come through our office repeatedly, we'll take that case. So again, it's a case-by-case analysis.
Mr. Chair, just a quick follow.
Yeah.
That gets to the question I really had, and that is there some way of tracking that? Because you will have those people that are continuously offending in certain ways, whether it's rifling cars or going through, trespassing. So they write a citation, it's declined. You still have a record of that, so
Yes.
you know, and you can follow up if it becomes a habit.
Exactly.
Thank you.
In addition, the prosecutors are typically or were assigned to a portion of the alphabet, so you can, if you have enough time there, see, I've seen this person before. Mr. Steele.
Do you do any negotiation or try to settlement or negotiate the offense down or any of that type of thing? or is it just either prosecutor or not?
It depends on the case, it depends on the charge, it depends on the facts.
Yeah.
We absolutely can accept a charge at a different level than what the police send us, and we absolutely can and sometimes do negotiate a lesser offense, but we really do try and charge it correctly and get a conviction for the charge that meets the facts
Right.
as best we can.
All right, can we let her continue with her presentation? Good, yeah.
Alrighty. And so I'll just throw out there that we are on duty 24 hours a day, 365 days a year. When our office is not open, we have a prosecutor who's on call to be available to the police department to answer questions and provide legal information and discuss cases. So we're always working like the post office. Just a quick
Even on
run
Sunday.
through what's a misdemeanor. It's criminal conduct. It's punishable by up to 1 year in jail. That's the definition. There are 2 classes under Muni Code right now. An A under our code is up to 1 year and a $10,000 fine. Those are the offenses that under SB 91 were limited to a 30-day max on the first. And Class B under our code is up to 6 months in jail and a $2,000 fine. Under SB 91, those are capped at 10 days.
Excuse me.
Yes.
Yeah, go ahead.
What's in terms of the crime itself, what's the difference between a Class A and Class B?
Class A misdemeanors are generally considered more significant. So assault is a Class A, DUI is a Class A, stalking is a Class A. Class Bs are the lower level thefts, disorderly conducts, some criminal mischiefs. They are not insignificant, but they tend to be a little lower on the scale.
So it's kind of how, if it's a significant impact on other people, violence and stuff, and lots of money that's allowed to be life-changing for the victim, then it tends to be an A.
Yes.
B.
Yep.
And probably this distinguished crew knows, but I didn't. We handle as a municipality the vast majority of domestic violence cases. They're Class A misdemeanors, and they unless it's a repeat or other things that make it a felony. But and how many prosecutors do you have doing DV
In
only?
domestic violence, we have 4 prosecutors dedicated to that type
just
of
do-
offense.
Yeah, Mr. Dunbar, and then we'll come back to you.
Thank you, Mr. Chair. So you said this is under SB 91 right now, right?
The 2 caps, the 30-day and 10-day, that is SB 91.
Okay. I see. For first-time offenses, they're capped at that.
On A's, the 30-day is the cap on a first offense.
Right.
On B's, 10-day is the cap on all offenses.
So, even repeat offenses, Class B, you're capped at 10?
Yes.
Then why does it say up to 6 months?
Because that's what's in Unicode.
Gotcha.
And SB 91 only limits us for offenses that are similar to state offenses. So right now in our code, we have some Class B misdemeanors that are at 6 months in 2000, and some Class B misdemeanors that are at 10 days in 2000.
Okay. Well, I do kind of want to stress something here, though. That this is very illustrative. Thank you. But you can take them to jail, right? I mean, so this is something that I think there's this perception that if it's a misdemeanor, they're not going to go to jail or they can't go to jail. But you're showing here that even if it's a 30-day cap, you can impose jail time for a misdemeanor.
So go to jail and impose jail time are 2 separate things when we're thinking about it. Go to jail tends to refer to the police making a physical arrest and taking to jail, and they stay in. And go to jail is what we do in our paperwork process as part of our sentence. So yes, we've always had the ability to impose jail time.
Right.
We continue to have that ability for most offenses, but not all. SB 91 did take jail out of the equation for thefts under $250 under all circumstances, for drug offenses first and second, and for violating conditions of release and failure to appear and driving license suspended, all 3 of which were reduced to minor offenses. So it did tweak with the jailability of those in some way. In terms of taking people to jail, misdemeanors are harder to get into jail than a felony. And the reason that is because there's a bail schedule. The bail schedule applies to misdemeanors. And it says that if it's a certain type of offense, then the bail is presumed to be OR, or own recognizance, which is simply go about your merry way. So it's not impossible. There are some misdemeanors that do have bail associated with them automatically, Officers can call and ask for bail to be imposed on something that's normally OR if they think it's appropriate, but there is a presumption that those cases will not be in the jail at the beginning of the case.
Okay, thank you.
It's great stuff. I have 3 in the queue. Senator Dyson.
Yeah, I'm sorry. What you just said really sparked a lot of questions.
Okay.
But the first one I was going to ask is, on the Class A and B misdemeanors, where do different kinds of prostitution and drug use and drug selling fit?
We don't have drug selling except for spice. Spice distribution is a Class A misdemeanor. Drug possession, which is what we have in our code for all other types of drugs, is a modified Class A misdemeanor. Prostitution is a Class B misdemeanor, but sex trafficking and solicitation are solicitation is a Class B, trafficking is an A, I believe.
All right, and Commissioner Monaghan said that one of the things that was exacerbating the situation is that bail schedules had not been adjusted. That's within a local purview, is it not?
The Alaska court system decided in the spring of 2016 to go to a statewide bail schedule. Prior to that, it had been local, so each presiding judge could create their own. Now it is statewide, so all 4 presiding judges from around the state have to agree as to what the bail schedule is going to be for each offense.
And has that happened?
It has, have they agreed? On many things they have agreed. Some things they agree to disagree, and then they go with the lowest common denominator.
Yeah, if I may follow up. So if somebody gets arrested on a theft, it's a second arrest, no convictions yet, one way to inhibit that person's activity would be to have a pretty significant bail and be able to hold them because of that. So that could only work if the bail schedule had been revised in a way that was helpful in solving the problem.
Ideally, yes.
Yeah, and the ideal hasn't happened.
It has not.
That's shocking.
As am I.
Thank you, Mr. Chairman.
You bet. Mr. Training.
I'm not going to fault the senator. Seneca, Class A domestic violence. I understand we do the majority of those prosecutions. And they've reduced it down to 30 days.
Domestic violence assault is exempted from that.
Okay.
So actually both DV and non-DV assault is a 365-day max. Other domestic violence offenses like criminal mischief or illegal use of phone, those kinds of things are subject to that cap.
Let me ask you a ridiculous question, Mr. Chairman. Ma'am, did we ask Juno to do this, or is this done on their own without any input from local authorities?
There was input from local authorities. We did not ask them to do it. It was their own initiative.
Thank you, Mr. Chairman.
It sounded odd there, but just so everyone understands, the illegal use of phone is a big part of domestic violence. Very often they're taking away their cell phone so they can't call anybody, and so it's often part of that. I had Mr. Peterson.
Thank you, Mr. Chairman. And so, my question is the Anchorage jail full, and are there times when we have someone we would like to arrest and incarcerate, but since we're filled up, we can't?
No.
So what is our current capacity?
I don't know what the capacity is of the jail specifically. I can say that the Anchorage jail, I have never found it to be full.
Wow, must be a big jail.
It is a big jail. But we also, Department of Corrections also has Goose Creek, which they can utilize. And we have a lot of defendants who move around the state, and so they'll end up incarcerated down at Wildwood, which is in Kenai, or at YKCC up in Kotzebue or Nome, wherever that is. In addition, they utilize the halfway houses pretty regularly, and all of our females are housed at Highland or at another halfway house. So there's a lot of space for them to move prisoners around to accommodate them.
And they also are using Goose Creek to keep prisoners while they're waiting for appearances.
Yes,
Right.
Anchorage defendants.
Right.
Yep.
Okay, great, thank you.
You can tell. I'm glad we got you here, Seneca, because they're very interested. I am too. So we'll let you continue.
Okay, so just distinguishing felonies are offenses that are punishable by greater than a year. Minor offenses are offenses that are punishable by a fine. The most common one is a speeding ticket. That's what we think of. So misdemeanors are right in between those two. I just want to mention, we do have ethical duties that are unique to prosecutors. We, in our office, seek justice, not a conviction. We don't keep stats about our conviction rate because it doesn't matter. What we're looking to do is come up with a just resolution for the case. We are always analyzing what we can do versus what we should do and trying to come up with the right answer. We are required to provide exculpatory information to the defense, and that's defined as anything that tends to negate guilt or would lead to evidence that could negate guilt. And so we have a very open discovery process with our defense counsel, very good relationship with them in that regard. And we do also always expect our folks to understand and consider the collateral consequences of any action that they're taking. In terms of caseload volumes over time, so I did every other year for the last 10 years or so. The bottom section are the DV offenses. The dark blue section is our general trial offenses. So domestic violence is obviously domestic violence assault. It's also any other offense that has a domestic violence component. So animal cruelty can be domestic violence. Illegal use of phone, criminal mischief, vehicle tampering can all be domestic violence. What you can see in this chart that I find interesting is that our DV caseload has remained very constant across the years. It is always about 2,000 cases. And the general trial caseload is the one that tends to move up or down. 2009 was our largest year. We had 11,396 cases that year with our prosecutors. This last year in 2016, we had 7,800.
Just before you move off that, so DV is a complaint-related business, and it's not going to vary tremendously based on the number of officers you have there. It's prioritized, and they're going to come up to it.
That's the thing. It is a priority for the police department, and obviously it involves assault on a person, so it's going to be one of the highest level considerations. So they'll always be making those cases.
And 2009 was about when we started flat or reducing the number of police officers. So that difference between 2009's figures, where you had 2,000 DV and then total of 11, so 9,000 non-DV down to about 5,000 non-DV. That's the number you expect to go back up.
Yes. Yep. And that trend for the intermediate years, it's consistent. It's a direct line, sloping line. It was going up until 2009, and then it hit that peak, and it's been going down ever since.
And I got two more, but how do I know that's not just you declining a lot of cases, Seneca? Do we know that?
I can tell you our decline rate was 29% in 2009. It was 24% last year. It's 24% this year. So it has come down 5% from its high, and it's been holding steady for the last 2 years.
Those are pre-decline caseload? That's what comes in?
Yes,
or is it,
this is what comes in the door.
That was my question.
I'm sorry. So I had Senator Dyson and then you, if you still have one, Mr. Consul.
That was it.
And earlier, when I asked about how many cases get pled out, you said something north of 90%. From the time of the arrest until the agreement is reached, how many days is that generally?
Well, it's anywhere from 1 to, I think the oldest case we have open in our office right now is 2013.
I don't care, but
So an average?
yeah,
I believe the average in district court is about 45 days.
wow.
And
Pretty good turnout.
a lot of that happened. If we didn't plead out the vast majority of these cases, we'd be swamped. You'd need
Yeah, no,
50
no,
prosecutors.
I got it.
And a lot of it happens at the initial arraignment. So you should, sometimes I did, but you should have a deal out that is, we're willing to do this, so that when they come to arraignment and the defense attorney's there, they can look at it and say, we'll take that. And a lot of work gets done there. So good.
In terms of looking at some charge-specific numbers, I picked 4 of the largest ones that make up our general trial caseload, since that's the caseload that's moving around the most. The white bar is what we estimate at the conclusion of 2017. The middle bar is 2016, and the bottom bar is 2009, which was our biggest year. Two biggest changes for us are DWLS and DUI. But DUI, I will say, is consistent from 2016 to 2017, and the percentage of the overall cases is the same.
Driving with license suspended, people is,
No, I'm starting at the
yeah,
bottom.
but I was given the acronym that you.
Oh,
was it?
yes,
Yeah.
thank you. Driving license suspended is the top. So for DUIs in 2017, they make up 23% of our general trial caseload. In 2009, they made up 23% of our general trial caseload. So that reduction matches for us the overall reduction in cases. Driving with license suspended went from 2,000, I believe it was 2,300 cases back in 2009 to 700 last year and 200 this year. And that change is directly a result of SB 91, reducing the driving with license suspended down to a minor offense, or that fine only, if it wasn't a court-ordered DUI revocation of the license. So that is an actual change in the caseload numbers. It's pretty significant. You can see from theft that it's holding pretty steady. It is up a little bit over last year. No, I'm sorry, it's down, where am I? It's going to be up a little bit in terms of percentages. So they're holding steady, but again, the caseload is shrinking. So in 2009, theft made up 14% of the general trial caseload. In 2017, it will make up 24% of the general trial caseload.
Mr. Dunbar.
So this is an interesting chart. So SB 91 went into effect at the
Middle of 2016.
Middle of 2016. I think there's a perception, I mean, certainly on the internet, there's a perception that the SB 91 has led to this massive drop in theft charges. But that's not what your data shows, right? I mean, if you're looking at here, the driving with license suspended, it's clear there's been a large impact there. But the data you're giving us shows that DUI is actually being prosecuted about the same rate, DV assault, same rate, theft, it's down, but it's not a collapse in the same way, so it could be related to something else or this. I guess I don't have a question. That's I mean, isn't that what this data seems to suggest? Is
Yes.
that okay?
Yes.
Okay.
There's a lot of discussion about the thefts and this perception that the theft prosecution is down or the theft arrest is down. I can't speak to arrest numbers. I can speak to our intake and say it's consistent. I can speak to our prosecution rates and say it's consistent. Part of the differences are the sentences are drastically changed, and so folks are out of jail sooner or never in jail, and so there's this perception of a revolving door, I think that's probably a big component of it. There's also that shift with the bail schedule to OR, and theft is an OR case, and so there's a lot of officers may not take a person to jail at all, and so visually for somebody on the street, they see a person not going to jail.
So does that theft include the under 250 thefts?
Yes, those are all thefts. We don't distinguish in our code numbers over and under, so I can't tell you how many of them are over 250 or under 250.
And so where before we might have taken a might or might not have taken a shoplifting under 250, depending on the circumstances, now it's just automatically a ticket, if you will. Or
It's not automatically a ticket, but it is automatically just a fine on the first and the second. So it's still treated like a misdemeanor with all the rights and responsibilities of a misdemeanor, but you can get only a fine on your first and your second.
you cannot put them in jail. So
Correct.
the same amount, if you will, of thefts can have a different public feel by that person being just released.
Yes.
Yeah, Mr. Trainee and then Mr.
Seneca, does that theft also include car theft? Is that in the,
No, vehicle theft is a felony.
okay. So this would just be anything under what dollar?
Under 1,000.
Under 1,000?
It used to be under 750, and SB 91 changed it to 1,000, so that's what we have.
Thank you, ma'am. Thank you.
Mr. Constant?
Yeah, so this case, charge specific numbers. Charged, does that mean charged by the police or charged by your office?
Charged by our office.
Right, so that's after all the declines and after any officer decision that this is not a good use of our time,
It's
right?
before the declines, because whatever charge, if it comes in as that charge and we keep it that charge but decline it, then it stays in our system that way. If it comes in and we change it immediately in our system to the new thing. So it's before declines, but it is after the arrest decision. So officer discretion will have already come into play.
So the question I have, and this is more of a philosophical question probably, is there the possibility that there's just decisions being made where people are getting screened out in advance because everybody knows this isn't going to do anything? And so, whereas the numbers are static because of the workforce that we have and the means to deal with people coming in, that in fact there is a shift out in the public because we aren't going to ticket them. We aren't going to go after that and do 5 hours of paperwork for 2 hours of jail time.
Right. I think you're absolutely right. I think there is most definitely the possibility that citizens either know or think that things won't be, that APD won't respond, or we won't prosecute, or the state won't prosecute, and so they self-select to not report. I think that's absolutely a possibility. There is also a possibility, and the officers can speak to that more directly, but there's a possibility that officers believe that we're not going to be able to take it, or the state won't be able to take it because of resource issues, so they will choose to exercise discretion and just give a warning or cite civilly or do something else. I think those are very real possibilities.
Thank you.
Mr. Dyson.
So, when SB 91 was being worked on the last 5 years, certainly one of the guiding things was to reduce recidivism. So, first-time offenses, people did something dumb, don't carry a felony around, or time in jail that tends to make them bitter and isolated. So that, but the thing that seemed to got missed on low-level crime is it says the second or third offense conviction, you get the hammer dropped on you. But here we've got guys, I heard that there was one guy that got arrested 13 times, never yet been to trial. And so catching the guy a second offense. So the question is there any way on the second arrest that we can hold them under existing law?
On bail?
Oh, yeah, have an accelerated bail, failure of bail,
Right.
and so on, so that disincentive is there and we get a bad guy off the street.
So there are a couple ways to do that under the existing paradigm. One would be that when the officers contacted that defendant the second time, that rather than utilize the bail schedule, they called a magistrate and asked for bail. Now, the magistrate has full discretion, so the magistrate could still say OR, but the magistrate also could potentially impose some amount of bail that would hold the person. The other potential option is that folks who are out on release on conditions by the court, when the court has issued conditions, are subject to that being revoked when they violate. And so committing a new crime or returning to the place where they committed their theft would be a violation, and they can be arrested for that. It's typically less than 24-hour hold and they're re-released, but there is at least the arrest and the temporary hold.
Yeah, so if I may, it seems to me there's an ideal solution that's available. It gets the bad guy in jail and so on and so forth, but are you inferring that the magistrates aren't giving us all the help? How do we solve the problem and use the solutions you just suggested?
Part of it is, I think, education. I think NAPD is doing a great job of that, but I think letting the public and letting the court system know how frequently we're seeing people reoffend repeatedly while they're still out on bail from that first offense. So the magistrates understand the significance of the bail that they impose. But the reality is that the court system and criminal justice in Alaska in general are really, really heavily shifting towards the idea of OR release being the preferred mechanism. So right now it's very, very difficult, even if you rearrest somebody, to get substantial enough bail to hold them for an extended period of time. So you might get them in for 24 or 48 hours, but if it's a theft under $250 where the maximum penalty is a fine, The judges are not going to hold them on significant bail. And until they're ready to resolve their case, they could be out there reoffending.
So that part of what I think Monaghan was talking about, is the bail, so on and so forth. And it just seems like you've enunciated a pretty good solution if we could get the courts to help us out with the reoffending folks.
Right.
Yeah, thank you, Mr.
That's something we ask the court system to do. We can set legislatively. Is it somewhere in between ours and their jurisdiction?
The bail schedule exists by statute. So the legislature could eliminate the opportunity for a bail schedule. What the bail schedule is left entirely to the presiding judges. So influencing them or discussing with them or exposing them may potentially affect what bail they choose to set. And of course, the bail schedule, while it's not binding on the magistrates, is very influential on the magistrates.
The legislature has said you court system can set the bail schedule, and so there's nothing we can do about that except ask them to either ask the legislature to stop doing that, to stop giving that bail schedule, or ask the court system to have a different bail schedule based on these factors. Mr. Constant.
Or to change the bail schedule through statute. But to put a fine point on what you're just discussing, I'm certain that this is not something y'all want to discuss publicly at this time, but the EGOW case that was at Arctic Boulevard, the paint shop, the guy was murdered by somebody who was out on bail after committing another crime that he should have been on bail for in some other universe. And so if we're trying to make a case, we have a very clear and crystalline example that we're dealing with right now as a city of a man who was murdered in 1 minute by someone who was in jail after being in jail and released from just out on bail again. And so, from the political perspective, we have a real tale to tell. From a judicial perspective, that takes time, and we look forward to seeing the resolution. But
Mr. Trainee.
Mr. Chairman, I think we always talk about a perfect storm. I think when you have the bail schedule being changed, SB 91 being done, maybe each separately was not a problem, but together creates a perfect storm. And now we have to live with it, and our constituents have to live with it. We've got to figure out how we change this thing.
And I guess I'd add treatment being cut back, so at the same time you were trying to use treatment as the alternative to that.
What money?
Those three, yeah.
Well,
Yeah, Mr. Reeves.
thank you, Mr. Chairman. And then on top of that, you've got the state cutting the budget for the prosecutors, and so they don't have the bodies to prosecute in many cases as they used to do. So the prosecutions become more selective, I guess is the word, and so you're only prosecuting the worst offenders.
Do you want to add our police force going down a bunch over the last?
It's been going up.
Eric,
Yeah.
that adds maybe a question of we might consider inviting as well at another time the state to have this conversation with them, the prosecutor's office, the attorney general's office, because they are a key link in this question, and it would be probably advisable to hear from them.
Have you seen the state? Sometimes you'll take a misdemeanor that's particularly egregious and recommend that it be prosecuted as a felony. Have you seen the state declining more of those?
Yes, the state rejects almost all of the cases that we try to refer to them right now.
Right, so I'm sure the committee understands, but that's a misdemeanor, but we look at it and say it has such violent behavior or horrible consequences, whatever, that it can be prosecuted as a felony. It came into us as a misdemeanor, but qualifies as that. Send it over to them saying, will you do it as a felony?
And that's both when it qualifies substantively. For example, there's a serious physical injury that was caused with a weapon, a strangulation is a really common one.
In DV, anyway, but
Right,
often
yes.
in DV.
Or it's a felony because it's a recidivist. So your third DUI in 10 years is a felony. Your third assault in 5 years is a felony. And both of those offenses, we're having a really difficult time getting the state to prosecute.
Yeah, Mr. Weddleton?
So if they refuse to prosecute, you can do it yourself then?
We can and do.
So, right, we do it as a misdemeanor, and with those limitations limited to a year. There's some very preliminary talk about, is there any way for us to do felonies, but it's complicated.
I've got one slide left.
Yes, great.
So So I just want to let folks know some of the ongoing projects that we have and some new projects. We participate in what is called the ADB SAIP grant, which is a grant that's funded in part by the city, you folks, and in part by the state of Alaska. That gives us those 2 compliance officers in our office, the ones that are doing the checks for DV offender compliance on bail. So that's a great program, and it's been very successful in catching our DV offenders who are very frequently violating their conditions and putting those victims back at risk. We are engaging in an e-filing project with the court system. It's a pilot project to allow us to file our charging documents electronically. You may or may not realize that the Alaska court system is still living in about 1987, give or take. Everything is on paper. And right now we file by printing out papers and sending multiple copies over to the court. So we're trying to move into about 99, 2000 and send stuff over the interwebs, so to speak. So there is going to be a small cost for us to get our system up and running to be able to accept the data from the court, but we're really excited to be doing that pilot project. And that's going to improve efficiency in terms of filing, and it's really going to improve accuracy in terms of data in the court's database.
When I left, you were doing a new case management system, I thought, that had the ability to have the defense attorney just look at the discovery and do something.
Electronic discovery?
Is
Yep.
that
Yep, we've been doing that for about a year and a half now.
great?
Yep. We are just beginning the initial stages of a DV offender probation monitoring program. Misdemeanors do not have probation officers. It's called informal probation. All it means is that if you reoffend within X number of years, whatever your probation term is, and we catch you reoffending, we can file paperwork and ask the court to impose some of your suspended fine or your suspended jail. So a lot of folks don't get caught because they reoffend in another jurisdiction, or we don't catch them in time. So our DV offenders who are out, we would really like to have some kind of monitoring for them. Now that we can't use the alcohol program for monitoring, we have nothing in its place. So we're working on a pilot project with the Alaska Judicial Council that will find an agency and pay for them to do monitoring of our DV offenders. And some research shows that not only does this improve, obviously, your victim safety or your victim sense of safety, but that offenders who are engaging in reporting or engaging in monitoring are actually do better on probation than the others. There's that sense of accomplishment when they're successful. So we're excited about that. We do engage in an online reporting for theft project with the loss prevention officers from several of the major stores in town in order to reduce the time that the loss prevention officers spent engaging in the apprehension and reporting of the thefts, to reduce the time that APD spent going and citing those folks. We worked with APD to create a project where they can file their theft reports online, and the paperwork will get put together and sent over to us for prosecution. So that eases up some of the constraints on everybody, and it's been very effective. And so I guess in light of that, I would say it's important to use the online reporting system. There are things that happen because of it, and it has been an effective tool for us to get more information about what's going on than necessarily what an officer can respond to.
Mr. Train.
Is it possible for you to give us a listing of the amount of felonies local state prosecutors have filed and their turn down rate? Because you said earlier before they're not accepting them. I'd like to know how many they're accepting versus how much we've taken to them, and what the state is doing, the local state DA.
Sure. I can do my best to find that out. Some of that data is available through the court system, and that I have access to. Some of it is internal data, like the decline rate, and that I will see if I can get. I will get you what I can.
Because
How
I
about-
told you the budgetary cutbacks, and that's a lack of staffing. They're in the same problem as you are, and the assets, a lot of attorneys.
Right.
How about this, Mr. Cheney? Ms. Thino and I talked a little bit about this, and without burdening them too much, if you have listed that prosecutors have given you of particular cases that they found that they had rejected that they thought were very worthy, and then maybe we can just do a discrete period of time, like ask your prosecutors in October, just keep track of the ones you send over and get rejected, so we can just have a block of time and say, I sent over 12 and they took none of them, or they took one of them, or whatever. Would that work for you?
Of course.
Yep.
Mr. Constant, yeah.
You know, it's not a question for you guys, more so it's a policy thing. I've heard consistently, and there's evidence that we are having people just not calling in, and we have an online reporting system. I think we're missing an opportunity, and that is to communicate the benefits positively of how reporting issues online saves time and gets the job done, and ensures that the public knows, that the police know that these issues happen. And so as I see you have online reporting of thefts and things here, it seems like we might consider some kind of a campaign to get the message out that this is how you do it and this is how you get the best results. So, sorry.
No, I like it, and Chief Dahl, every time it seems like they're seeing, will say, report the crime, report through whatever process, because even if it's frustrating, even if you don't see the exact results, even if there isn't a result in that particular case, actually, it allows us to know that that person came through and maybe catch them the second time, or we hope to respond to that individual complaint, but if not, at least we know that it was there and we can use it second time. Right, Chief Dahl?
Yeah, that's absolutely correct. And we talked about it again this morning, but every chance I get, I do remind people, even if it, you make the report over the phone or through the online reporting system, and then I think Seneca's online reporting system is even a little different because it's taking referrals directly from LPOs. Is that right?
No, they go through.
They go through
use
ours?
yours,
Okay.
yeah.
At any rate, the online reporting system allows us to have that data, like Mr. Constant said, about where things are occurring. And, the police department is using crime report data to make decisions about resource allocation. So if we don't have that information, it makes those decisions not as good as they could be.
And it seems like we should run a campaign along those lines. Invest a little money, tell a positive story about how that works. Because what I hear mostly, people are frustrated with it, and I think that's a framing issue that we could actually reframe it and make it something good.
So I have Mr. Training, but for either Captain Case or Chief Dahl, does APD meet regularly with the retailers on shopliftings? Is there a working group of that?
I believe that there is, and we have a detective that participates.
Which detective is that?
I think it's Detective Dupuy, isn't it?
Dupuy? Okay, good. I was trying to make sure it's the same thing. So I talked to him. He was very helpful, and he meets with the group. He was going to give me some information on that. I'm learning that LPOs aren't usually authorized to, say, speak for Fred Myers, so it's harder to have somebody who knows all about LPO, loss prevention officers. And so we've got to be a little more careful before they can have the authority to speak to us about it. Yeah. And so I'm going to be, I've started and I've gone through some of them, and I'll be tracking or trying to get somebody who will talk to us on the record about what's going on with that. So that was me. I had Mr. Trainee and then Mr. Weddleton.
Thank you, Mr. Chairman. Seneca, a quick question for you. I see next reports all the time that look for this escapee, but aren't these just walkaways or runaways? Because escapees to the public means they were in restrainers of some kind, but they're not in halfway homes. This would be walk in the front door, walk out the back door, and they'll run back. Aren't there really walkaways? Who defines them as escapee? Is that state law or us?
Well, walkaways from a halfway house, I don't know where that term came from, but that is an escape. It is charged and prosecuted as an escape. You are required by the court to be in custody, and you are housed at the halfway house, and you're required to be there unless you're specifically given permission to not be there. So we treat them and consider them escapes.
But they're not under any restraint of any kind of halfway house.
My understanding is that most of the contracts for the halfway houses, the employees are not allowed to put hands on a person to stop them from leaving.
Okay.
Yeah.
Because I get so many complaints and said this insane. Why do you have so many escapees? The reason they walk in the front door, walk in the back door. And if the people there are not allowed to stop them, it's odd to call them an escapee when they're actually just a walkaway or runaway.
Right.
I think the reason you haven't heard the term is it's Mr. Trainee's term. It may not be.
Actually, it was a term we used years ago.
Yes, it is a common term. But I do think it's important to remember that halfway houses house people who have committed DV offenses, people who have committed assault, people who have committed other violent offenses. So technically they do walk out the door. Sometimes they run. I've heard they go out the window. But any of those ways, it's still an escape.
I was talking to the guy that worked there. He said we're not allowed to say anything to him. We deal with them at all.
Right.
See you later.
Not even
Come back later.
Oh, you can say goodbye?
I don't know.
Mr.
Thank you,
Weddleton.
Mr. Chairman.
I just want to give a plug for the Alaska Organized Retail Crime Association, which is the group of retailers that meets, and I think we're meeting every couple months, but I've been doing it for 5, 6, 7, 8, 9, maybe 10 years when Jackie Kahn did it, but it's been a big help. We emails, constant emails. I must get 5 a day with pictures and description of what was stolen when. And if it's the kind of thing that I sell, use at my stores, we make note of the name, put it on our computer, we won't buy for them, or we'll get a case number or something, we'll call, and it's been very helpful. We've stopped people, and they've been arrested because of it, and we've helped build cases because we'll all join together and say, yeah, it's the same guy, got us too. It's tremendous, and it makes us all feel good because we're contributing. And that's my little shop, working with Costco, Walmart, and APHIS, and everything. So to me, it's a huge success.
Maybe I should start there. That'd be great. So that concludes your.
I have two more things.
That'll take us 20 minutes. Okay, go.
I don't think so.
All right.
Okay, so another thing that we're working on are code updates. There are 2 specific ones I'm working on. One is a large-scale Title 8 and Title 9 update, that 8 being our penal code, 9 being our driving code, that will bring us in line with the SB 91 requirements, and will clean up a lot of things that are in the code, tweaks and changes that our prosecutors really need to be able to be a little more effective. We have Title 9 done, but not formatted. Title 8, I'm about a quarter of the way through. So that will be coming to you hopefully this fall. And then the other one is a joyriding statute that I believe is coming to you pretty shortly. There's a very, very high mental state on the passenger riding in a stolen vehicle. And obviously vehicle thefts are an ongoing problem here in Anchorage, and APD is trying desperately to address that. But when you get 4 folks in a car and you can't really deal with 3 of the 4, because the mental state is so high, it makes it very difficult to put consequences on everybody who's associating together. So there's a proposal coming forth to reduce that so that we can successfully prosecute.
From what to what? Knowing that it was stolen
From knowingly to negligent.
negligence
as to whether it was
directly.
stolen. Yep.
I may surprise you to learn I have Mr. Dyson, Mr. Training. Ma'am, are we speaking loudly enough? Most of the time. Speak up, Mr. Dyson.
I understood that there were some 400 jobs you couldn't get in Anchorage if you had a felony conviction. And I haven't verified that myself, but in the stuff that you're looking at and rewriting, does that stuff come up in what you're looking at?
No.
All right. What
'Cause
section is that in?
What section is what in?
The precluded occupations.
I have no idea.
Thank
It's
you.
not in either of my titles.
Yeah, all right, thank you.
And she only prosecutes misdemeanors, so
Sorry?
she only prosecutes misdemeanors, so a felony ban wouldn't be.
Yeah.
But read us, and then Mr. Training.
Really, because you're rewriting 8 and 9, and it comes to it, you include in the AM of it, how this changes what it was before
Yep.
versus how it is now. Because I know SB 91 went into effect for parts of it. We had to reduce some of our fines and fees to bring it in line with the state.
Yes.
So I'd like to know if we, as you're doing this, if we have to do that with this stuff.
I'm doing a change by change
Thank you,
explanation
ma'am.
of what we're doing.
You know what I want.
Yes.
Thank you, Mr. Chairman.
Appreciate, yeah, Mr. Constant.
Back on what Mr. Trainey had mentioned about the escapees, I do too hear about that a lot, and I'm wondering if there's any reason why the reports couldn't go out and say, in these cases, left custody, as opposed to escaped, because it creates a perception of left lockup, right, to the public, whereas you use the term left custody, and that custody is probably a term of law as well. And so I would wonder if there's not some value in considering that, because it would more accurately to the public, I think, represent what's happening, as opposed to the sense of, oh my God, another one, bang, bang, ran away.
Can we look at that in Nixle to change? If there's truly an escape, we all want to know about it, and then if there's just, and not to diminish it, but if there's a halfway house walkway, that's a different level of
I'm sure
concern.
DOC would appreciate, making it seem like not as many people are
Walking out, yeah.
Yeah, it's something we could talk about. I mean, to us, it is an escape. It gets dispatched as an escape. That's how when we make an arrest or get an arrest warrant for that person, it's for escape. So
Okay.
I guess it's just a matter of we want to try to kind of adjust the way people are seeing that.
We understand you charge it the same. It's perceived very differently depending on what's happening there. Thank you for your presentation. I want your help, Seneca and APD, on the resolution, and we're running out of time. We have 15 minutes. Chief LeBlanc, I apologize.
We have
When-
45 minutes, don't we? We have to
I
three.
thought we were noticed from 1 to 2:30.
Here it says 1 to 3.
Who's right, me or that paper?
Where is Amanda?
But I should have, when you said that you had something brief, I should have,
Sir, Mandy says we have until 3 o'clock.
I should have done you first, and so I apologize.
Fine.
We know that your time is valuable. Whatever sentence you have to enlighten us with, go ahead.
Well, I did accept that challenge.
Okay.
And if you allow me, and it reads, I just want to remind you of what I announced at the September 6th meeting. That specifically, the fire department will introduce at next Tuesday's assembly meeting a supplemental appropriation for 2017 of $818,902 to pay for a fire department attrition academy, stemming primarily from the failure of Prop 2 in April, and I urge your support of that resolution. One sentence.
Yes, it was. A clause at the end, but it was not a sentence. Thank
Very
you.
expensive sentence.
Again, I apologize. I should have moved up on the agenda.
That's fine, because we have pre-agenda right after this.
Okay.
So I had to be here anyway.
All right. I was going to say you're free to leave, but you're free to do whatever you want.
So, Mr. Croft, if I may just say
Yep.
the very last thing on my list,
Ah.
then I'm done. We are looking to add a Prosecution Citizens Academy. I recently went to a conference for leading prosecutors, and that was one thing that the folks who had done it had said was really useful to their communities, was to explain exactly what I'm talking to you about, and more about the actual charging and prosecution process. So I'm really excited about us doing that. We hope to get it off the ground and running sometime this winter.
I don't get what you just said, if I may.
Yeah. Tell.
What is the academy? You gonna train everybody in Anchorage, all the citizens?
I would love to
Explain.
train all the citizens. No, it's modeled off of the Police Department Citizens Academy, so it's usually, for them, it's about 6 to 8 weeks, give or take 10 weeks. For us, it would probably be just a couple days, but it allows folks to come into the office, to see what files look like, to see what we do, to see how the court works, and hear from players in the
I
system.
got it, thank you. Thank you.
Now that's your presentation.
That's it.
Excellent. So, on the resolution, I'd ask the committee to take a look. It is my draft, so people are free to provide any. Mr. Dunbar, did you want to
I have
start?
quite a lot to say, so if other people want to talk first about it, I'm comfortable with that.
Let me do this. So, I see Melinda Freeman in the audience. Melinda, I had said in the whereases, the state of Alaska has not met its commitment to use money saved from reduced jail time to support new and expanded probation programs or increased drug and alcohol treatment. And that is obviously my impression, or I wouldn't have stated it, but is that accurate, or should I modify that in some way?
Well, I can't confirm that the state of Alaska has not met its commitment to use that particular proposed savings to support treatment programs. What I can state is that according to the treatment providers, there has been continued reduced funding for substance abuse treatment, as well as the state of Alaska reducing funding for treatment providers that bill Medicaid, with the intention to compensate for the reduction in funding from the state of Alaska by billing Medicaid, and that has not occurred. By billing Medicaid, that has not increased the revenue for treatment providers. But Mr. Constant would perhaps also be able to respond to that.
Yes, and I can specifically state that since 2016, the Department of Corrections has cut its treatment program out of Goose Creek, out of Highland, out of Fairbanks Correctional, out of Wildwood and Kenai, out of the Seward, Juneau's Lemon Creek, out of Lemon Creek, out of Spring Creek. They don't exist. They've also closed the community-based programs in Anchorage, in Fairbanks, in Kenai. They did refund the Kenai program, but that's the only community right now that they've refunded, and that was $4 million in the last year that they cut out of treatment services. Now, I will disclose that my employer was the provider of those services, and we walked away from the contract because the state was demanding more services than they were willing to pay for. So if you signed on, you were underwriting the state's provision of treatment services. But that's over $3 million of reduced services in the last year alone, very concrete for recidivists, for DOC people. And so it's very specific and egregious, the reduction that's going on.
So I get, we to some extent had to do this quickly to try and get it on the schedule for the special session so it could be relevant, and some of these were moving targets. I guess I'd propose, though, the committee can help me decide, if you have edits to the whereases, which are not vital but are important to get right, that you can send them to me, not everybody, because open meetings, but you can send them to me and I can make corrections. I'd rather concentrate on the things we resolved than the things that we said were background. But do people have important changes to the whereases they'd like to bring up now, or can we do it that way? You seem to have some.
It's just a couple small ones.
Okay.
I've got a bunch.
All right.
Got a couple.
I'd rather, talk about the substance and then have me change or even delete some of those. Is that acceptable to you, Senator Dyson? Sure. Let's at least, if we can, start with the substance, and maybe we have time to get back to the whereases. So, title is important. Go ahead, Mr. Weddleton.
Well, I would just delete reverse or, because we don't, that's kind of say totally flip SB 91, and I don't know if we want to do that.
What line
And
do
you
you
meet
want
the
it?
same,
In the
get
title.
the same goal and to alter.
So suggestion is to not say reverse and just say to alter the effects of SB 91 passed in 2016.
Yeah.
And from a wordsmithing perspective, I would add the negative effects, because
See,
there are many who would argue that there are good effects of this bill.
oh, I see what you mean.
Yeah.
Well, but if you read it that way, it implies that there are only negative effects. If you just read it in the sentence.
No, it's the only effects we're altering are the negative ones.
Why are we altering the effects? Shouldn't we just be altering SB 91?
Nothing can alter SB
That's
91,
what
it
you're saying.
passed.
Yeah. Well, no, that's what SB 54 does that. I see what you're saying.
Title's important. Any other title changes?
Yeah, I missed part of what was said, but you want to strike the word reverse.
And or, so it just reads, and to alter the effects.
Yeah.
And then Mr. Constant said, and to alter the negative effects, because we don't want to alter all the good ones.
Yeah, and I would have said alter some, or alter, some, because not
Right.
all of it, but some way of crafting that.
I would support Fred's suggestion over Chris's, not because I think Chris had the right idea, but I think if you read it that way, it sounds like there aren't positive effects. Like, if you said alter some of the effects of SB 91, that to me more clearly captures what we're trying to do rather than alter the negative effects of SB 91, because
In effect, this is a work session on this resolution, so we're not doing formal amendments, but is
Yeah.
that just as good for you?
Yeah, I just want to make sure we leave room for the positive effects.
Alter.
I totally agree with that.
Absolutely.
Yeah.
Alter some of the is now the operative title, effects. Huh? No. And so that's the question, is it in a condition that it should be submitted on Friday for inclusion on Tuesday or not? On the substance then, and we'll come back to the whereases.
Yeah.
Anchorage Assembly supports the prompt passage of SB 54 with the following changes. Ms. Thino and Chief Dahl, in your opinion, should we be supporting passage of SB 54? We'll get to some of the things we're caveating or changing, but in general, is it moving us in the right direction from your perspective?
So I would say yes, by and large, it does move in the right direction. It targets a handful of things in SB 91 that have not panned out as well as we hope, or administratively don't work that well, and attempts to target those. So I do think overall it's a very positive movement. There's one thing in there that I think is a move backwards rather than forwards, and that's what is identified here as subsection A.
8, yeah. A, that is 8, yeah.
Yes,
Yeah,
leave
right,
it
right.
eight.
Chief Dahl or...
I would say that yes, it does generally move us in the right direction, and I'm going to let Captain Case speak on it a little bit because he's got a tremendous amount of fine detail experience with it.
Yeah, the theft portion is obviously the biggest thing, as well as the violating conditions of release, which I believe Mr. Dyson talked about during sending his presentation. And so forth, those things are going to have an immediate impact on the way that police officers on the street are able to do their job.
Okay, so let's do those two. So section 1 is the violating conditions of release provision, right?
Section 1 and section 2.
All right, so, okay, hold on, let's do one at a time. Section 1, what problem, Ms. Thino, is section 1, you have the 54? Yeah, I'm talking about 54, sorry. So I'm still on, we have 3 specific things that we say differently, but the base idea, should we say we like 54 or we don't like 54, that's the first sentence, so that's what we should do. So just a second. So on 54 itself, which Senator Dyson printed out for us, section 1 of that bill makes what change, Senator?
Section 1 changes what we call a violation of conditions of release from an offense to a crime. Crime is something that has jail as a penalty. Section 2 classifies it as a Class B misdemeanor specifically. And then Section 9 specifies that the maximum penalty is 5 days in jail. So what these 3 sections are doing together is taking the VCRs, which are now a ticket with a $1,000 fine, and they're returning them to what they were, which was a misdemeanor, but they are keeping the penalty very low.
Okay, so again, just to get everyone on the same page, there are 2 ways you put conditions on somebody who's done a thing, and one is what she's saying, VCR, violation of conditions released. I'm going to let you go, and here's what you can't do. You can't go back to that victim. You can't drink any alcohol. You can't drive anymore until you come back. Anyway, things that are part of your being released. The other thing we're talking about is PTRs, petition to revoke probation, which is you were convicted of a crime. You were sentenced to 10 days with 60 suspended, and you might get that suspended jail time if you recontact the victim, go back to Fred Meyer's, don't do your alcohol treatment, those things. So they're flavors of the same thing, but they're not identical. The things you can't do pending release, or because we released you, the things you're not supposed to do for a period of time as part of your conviction and parole. And this is just VCR issues.
Yes.
So this is just conditions of release, and it goes to a flavor of what Senator Dyson was saying, which is we've got these people who have been released on a thing and are doing the same thing, and they stack them up, and we can't do anything about it, or we can't do anything effective about it. Senator Dyson.
Yeah, Seneca, I was just delighted what you said in response to it. I was asking what other tools we have. And so, and your answer was the police can act, cop can ask the magistrate, jack up the bail, not let them out on the warrant, and so on. Courts are supposed to restructure this stuff, and so on. So I want us to say we want that whole chain fixed. Police know that they can call the magistrate, because this is the second time the guy's got busted. Not convicted, busted. We want to hold the guy. And the magistrates know, hey, you've got the keys to the Crossbar Hotel here. We want to keep this guy and get the magistrates to act more responsibly and habitual criminal. And we want the bail set so that if we've got a bad guy and we've busted him twice or 3 times, he's got $10,000 or $25,000 bail because we're pending the next trial.
And what I wrote down on that is you and I working on a letter to the court system saying we would like you to revise the bail schedule. And anyone else who wants in on it, of course, is welcome to. But I think that'd be interesting. It'd be an interesting thing whether they say nothing to it or whether they are open to it. I have no idea, but we'll try.
So what you're just saying is we want to restrict this to changes and amendments to 54.
Well, no, I mean, you're right to say they're hand in hand, so we can do both. We can say this is a good provision of 54 for these reasons, still keep the penalty low for these violating conditions, but allow us to use the tools we had, and then also talk to them about the bail schedule. I think both could be appropriate.
In this document?
No, probably the bail schedule's got to be a separate action of ours.
Yeah, but one we ought not to let go of.
Right, so I wrote it down on my big list. Mr. Constant.
So this is like a ton of information, and there's a lot of kind of opinion about these issues, and I'm wondering if we ought not to consider having a short half-hour work session on Friday before we have our land use plan meeting, that we can, everybody send in your comments, that you can come back with a revised version, and we can deliberate with something in hand. Because I'm a little bit overwhelmed with the content that I see before me, and I feel like suggesting that we could move forward on Friday for something to act on Tuesday without having sat down only to talk about this is a risk of failure.
Okay. This is the reason I wanted to get to those 3 points, so we could all be on the same level of knowledge about all three of these, and it may be that it's too much and we say let's postpone it for 2 weeks, or it may be that we get to a level of knowledge that people feel comfortable just doing action on Tuesday. Open to either one of those. Let's now, so that is two parts of 54. We're still on do we like 54? Think we do, but we're testing that out. The first, second, and ninth sections restore some limited power to use VCRs, conditions of release, and 5-day penalty. You mentioned thefts. What does 54 do on thefts?
54 changes the penalty range for thefts under 250. Right now, it is a maximum $2,000 fine on a first offense, maximum $2,000 fine on a second offense, and a maximum sentence of 5 days in jail, all of which have to be suspended on your third and your subsequent until the end of time offenses. So there is no possibility for jail time unless we revoke your probation, and then it's only up to 5 days. What SB 54 does is it changes that. It brings that 5/5 penalty down for the first offense. The second offense, again, this is theft under 250, is now up to 5 days of active jail time, and the third and all subsequent offenses is now up to 10 days of active jail time.
You used 5/5. That means I'm sentencing you to 5 days with all of it suspended, 5 suspended. So it's really no time in jail. 5/5 means you walk, but I've got 5 hanging over you. Everyone understand what it did on theft to restore some of that ability? Okay, for those two changes are helpful from both of your perspectives, from APDs and.
Yes.
All right, so then there are 3 areas where in meeting with the prosecutor's office and APD, they thought either SB 54 had been under-inclusive or was doing a thing that they did not like. Section A, which proposes deleting Section 8 of 54, Seneca, what is that change?
So the case that you have in front of you, the case that was handed out, the MLA v. Brooks, there was disagreement between the city and the state as to when SB 91 passed what the maximum penalty was for a second offense, a repeat offense. We took the position that the language in SB 91 provided that your first offense was capped at 30 days and your second and all subsequent offenses were capped at 365 days. The court system took the position that it was 30 days for your first and your second, and you didn't get to up to 365 until your third. We litigated the issue, we won. So the Court of Appeals found that the language said your first is 30, your subsequent's up to 365. While that litigation was still pending, the Criminal Justice Commission took the issue up and tried to put a Band-Aid on the situation. So what they put into 54 was, if it's a first, it's 30 days, if it's a second, it's 60 days, and if it's a third and subsequent, then it's the 365. What we would like to see happen is to remove that provision, that Band-Aid, and allow the Court of Appeals decision to stand. And if I may give an example of how this is relevant.
Yeah, first just, this isn't DV and it isn't DUI, right?
It's everything.
It's everything.
It's not, I'm sorry, it's not assault.
Okay.
It's everything else, including DUI, and that's my example that I'd like to
Go ahead,
use.
yeah.
So on a 30-day cap, a DUI sentence, first offense has 3-day minimum. So a typical sentence will be 30 days in jail with 27 days suspended. That 27 days is the suspended time that hangs over your head while you're on your 1 year of probation. In a second DUI offense, the minimum jail time is 20 days, and it goes up from there if the case is aggravated, so you have a high breath alcohol or you caused a collision. So right now, it would look like a 60-day sentence with 40 or 20 or 10 suspended. It's not uncommon for us to give 30 or 40 or 50-day sentences if it's a really egregious DUI. What that means is for the 2 years of probation time, you've got only 10, 15, 20 days hanging over them, which is, in terms of how we work, not a significant amount of time. What a typical second DUI is in our office is 180 days with 150, 140, 130 suspended. So we're getting a higher chunk of suspended time to help make sure the person does their alcohol treatment, gets their ignition interlock device, doesn't reoffend, doesn't drink.
Amy just signed off.
Okay. Ms. Dombowski had to leave, but she was on up to this point. And because right now they've already had their second DUI, that 150 of suspended, I need more than the 27 or 30 I had before to make sure that they get their alcohol treatment, they do the other conditions that they've said. I have Mr. Dunbar and then Mr. Constant.
Thank you. So I think we've moved on to these sections where we're talking about the changes we want in SB 54. We have already sort of conceptually, I mean, if we're going through this in the way I think we are, conceptually agreed that the rest of SB 54 is okay. And I don't think I actually am comfortable with that idea. And I think Mr. Constant agrees with me because we haven't really had time to go through this process. So, and going through these sections, they don't look like a big problem. But I want to make a couple of comments. First, I don't think we are as time constrained as we are sort of making it out to be. The special session that would deal with this isn't until October. So if we were to pass a resolution, work through this and pass a resolution at our next meeting, which is the 26th, I still think it's plenty of time for it to go to the legislature for them to see it. Even before that, though, I kind of do have a question about whether this is appropriate action for us to take. Now, we have been usually resistant to the idea of doing quote-unquote political resolutions. And I know I've sat through last year some comments by Ms. Dombowski about we shouldn't be doing this. It had to do with automatic voter registration. We generally limit resolutions, if they are going to be more political in nature, to things that are directly under the control of the municipality. And I say that because I think I might have one of those coming forward in the not-too-distant future. Now, I think you guys are making a cogent argument here that this so impacts the functioning of our city that we should be able to comment on it through a resolution, right? The thing I did was through a letter that I'm asking you to sign, not a resolution, specifically because I'm trying to avoid this kind of flood of political resolutions, because there's many things that they want us to pass resolutions to do, or my constituents do, and generally we don't take sort of abstract political stances through resolutions. But I think I'm convinced by the testimony and by the two people putting forward the resolution, that this is sufficiently in our purview that it is appropriate. But I want to make sure that we don't make statements that are ill-informed, because it's a really complicated issue. Senator Dyson said it took 5 years to get to SB 91, right? And SB 54 is going to go through a rather lengthy debate. It's already been debated this whole session. So I think we should take a little more time before we move forward with this resolution. There are specific whereases in here that I am not comfortable with. I think they are too broadly written. I really like your focus on the treatment aspect of it. I think that's really important, and the fact that you guys wrote it in that way and talking about the funding that didn't exist, I think that is really important. I have one other really specific changes that I want to add to as a D to this, and so, Mr. Chairman, if you will, after we've gone through these, I'd like that opportunity.
Absolutely.
Okay.
And I think, I had heard the call for October, and that created the need to get this done by September 26th. The more detail I got in researching, I think it's late, is it 23rd? When do they go back?
Well, I've already lost a week.
Yeah, so it's not early October. I'd gotten in my head somehow that it was early October. So probably, 20th, 23rd, something like that. But anyway, it's later. So action of ours by the 10th is sufficient, and we don't have to hit the September 26th. So that's fine to wait, and I won't put it in this Friday, and we have more time either for another one of these meetings or some other mechanism workshop or standardized in the meeting. So
Yeah,
that's
so
kind of my list.
I appreciate Mr. Dunbar's comments. You, Mr. Croft, and Mr. Peterson can agree or disagree. Another piece of paper showing up in a legislator's inbox
It's not appreciated.
is not very good way of getting things done. I made this point, Mr. Peterson's legislative committee the other day. We really want this stuff done. We get our stuff together on what we want to say, and then we go and meet with the relevant committee members, that we have relationships with or influence over, and make that our responsibility, talk to them face to face, explain the reasoning and the problems and so on and so forth. And if we want something done, otherwise, Mr. Dunbar said we're all just beating our chests a little bit in public and going home feeling good and haven't done diddly. So
It's not exactly what I said, Mr. Dyson.
That's what he heard.
That was
I
his
said it better
summary.
than you. But, so, I think a deliberative process, but I strongly recommend it. Coincidentally, or with that, we come up with a strategy to get to the key people. Senate's dealt with it. I'm quite comfortable that they will make any amendments that comes back to them. But we need to get to the people in power in the House, and that's the Judiciary Committee and the leadership. And I'm sorry I said it.
Mr. Constant.
Yeah, two things. Back to your point, Ms. Thano, about the sentencing time, or the suspended time. We can gather evidence, actual concrete evidence from the local treatment providers who can tell you, since this is passed, there's been a massive drop in utilization of treatment services because there's no reason for them to come, right? So we can actually gather concrete data to that point. The ASAP programs are crashing. Aquila has empty beds. There are treatment providers across the city. People laugh, oh, what, treatment? We come and pay $200 and they run away, they're done. And so we can gather that information if we need. Then I'm going to take just a moment of privilege. I have to leave in 3 minutes, and I wanted to speak briefly to APD and note for the record that last week was a hell of a week. That we had 3 murders on one day. We had another murder a couple days before that, and even yesterday another one. And I've been following the crime issues of the city for a long time because it in fact impacts my neighborhood greatly. But something's different this time, and it's to your credit that this week every single one of the alleged perpetrators is in custody now, and within a day or a couple of days of the incident. So I just want to say thank you to APD, the increased responsiveness, meaning that when a crime is happening, somebody's in jail right now. And so that's evidence that you're ramping up, to me at least, and that your work is being more successful. So there is hope in all that tragedy that happened last week. So thank you.
Excellent. Sorry you have to leave. Until just recently, we had all 11 members of the Assembly. Mr. Muskie had to go, and now Mr. Constant. Then if we can just use the remaining time to get all on the same page, work session style, about the next 2 points, I think we will have achieved at least moving that forward so we're all talking the same language. Ms. Thino, what does B do and why?
So SB 91 restricted the use of ASAP. ASAP is the Alcohol Safety Action Program. It's the monitoring agency for people getting alcohol treatment. So they serve kind of as a modified probation officer to ensure that people are going to their treatment. They do the referral process. They do some monitoring. SB 91 restricted the use of ASAP to DUI offenses. So all of our DV assaults that involve alcohol, all of our resistings that involve alcohol, all of our other non-DUI offenses that involve alcohol, including reckless drivings that are reduction from DUI, cannot go through that ASAP office, which means that if we want the person to go to alcohol treatment, the prosecutor themselves has to find a way to monitor it, which is extremely difficult to do. So we would like to have the ability to do that treatment monitoring for any offense that has alcohol involved.
You can translate a little, if there's some evidentiary problem in a DUI conviction, you think it's valid, but the machine wasn't working right, or the stop was questionable or something, but they have, but they were drunk there, there's a lot of evidence to believe that. You can reduce it to reckless driving, they'll plead to that, but you'd still like them to get alcohol treatment because alcohol's right, or alcohol-related everything that happens, including domestic violence often. And so having the ability to have alcohol and somebody to see whether they walked away from the program is important. Mr. Weddleton.
I just want to be clear, so when you say restore the Alcohol Safety Action Program, that's because there's a staff that will actively monitor this.
The
It's really-
program, yes, I'm sorry, the program
People.
still exists, the same folks are still there, just now they are only monitoring for the DUI people, whereas before, SB 91, they were monitoring for everyone we referred to them.
Mr. Trainee.
This is to Eric, Fred, and Pete. We're in the legislature. How much money comes into the state based on the alcohol tax? Because it's a state tax. What are we talking, $40, $50 million? How much comes into this?
I don't know. I remember a higher number, but I don't know.
My argument is part of this was to reduce the cost to the state. Well, if the alcohol money tax is coming in, we should be able to use it to add these into this program, because if alcohol is all involved, they should have alcohol treatment to stop that from happening.
True.
Can't
So,
designate, unfortunately.
I know but you can dedicate, not designate. We can designate. State.
all right, and so anything on the ASAP, or Alcohol Safety Action Program, if we could get through this, I think it'd be productive. So C, restore the ability for over 1 year of probation. What would C do?
So previously, under municipal code and under state law, you can impose up to 10 years of informal probation on your offenses. That's very rare. That was not frequently done. We typically do 2, 3, 5 years, depending on the criminal history of the defendant. SB 91 reduced all of those probation terms, but the one it reduced most drastically was for non-person crimes. It is now capped at 1 year. So if you're going to find them violating their treatment, if you're going to find them reoffending and revoke their probation and impose any of the suspended fine or any of that suspended jail time, it has to be done within 1 year, which is a relatively short amount of time.
So what types of crimes would it be important to have more than a year on? And then I have Mr. Dunbar.
DUI, for DUIs, it's 1 year on a first, 2 years on a second and subsequent. I believe both of those are significantly too low for folks who have a high recidivism rate, if their BA is high. Any Class A misdemeanor other than assault, so we're talking about resisting arrest, we're talking about stalking, stalking isn't a person crime, we're talking about criminal mischief, we're talking about significant property crimes. All of those, I think having some additional time to monitor the folks for those treatment conditions or those probation conditions is important. A lot of times we'll impose a no contact provision or a no return to this place of business provision. Those are only effective for however long that probation period is. So you can only protect the business owner, you can only protect that location for as long as a year in a lot of these cases.
Mr. Dunbar.
Thank you, Mr. Croft. Mr. Chair, I think you're right, Seneca, that it does sound like in some cases 1 year of what is informal probation too. There's no right for misdemeanors. We don't have the monitored probation. But 10 years seems really extreme to me and really long. And I know that you guys don't often seek that. But what we're asking here is to get rid of the restore the ability for over 1 year probation. We're not asking for any kind of cap. So that would send it back to 10 years, right? And to me, I'm not comfortable with that. With this language, you see what I'm saying? Like,
Yeah, I don't think it
1
does.
year is too short, but if we go back to 10 years, that seems way too long for me.
You sent me language that was in between. Hold
I
on.
said 5.
You said 5, but that's not what our language in here does. So, yeah.
Sure, and if I may, this talks about the 1 year probation. The maximum probation for anything is 3 years. So for a DV offense, the maximum probation term is 3 years.
There was a 1, 2, 3. 2 was DUIs. Or no?
2 is repeat DUIs.
Oh, repeat DUIs.
3 is DV offenses. And so we have folks who are on their 7th, 8th, 10th domestic violence assault, and the maximum probation term is 3 years. And again, you know, folks will reoffend at a variety of periods of time, but that's the stick, right? The probation period is the go to your your domestic violence intervention program treatment, go to your alcohol treatment, don't contact the victim, but we only have for 3 years, as opposed to the 10 we used to have. Mr. Dunbar, those are the types of cases we typically did 10 years in, and the rare instances we did, which were the significant repeat DUIs and the significant
DVs or DUI?
DUIs and significant offenders. My recommendation was to increase it to 5 years across the board, which I think is a good compromise to still keep it lower than 10, which can seem extreme to folks, but gives us substantial time to watch folks and make sure that they're not violating.
I will bring this back for another session of this committee or another work session or some other substantive. Anybody wants to individually send me suggestions, that is great. I'll try and compile them. Don't do it to everybody because it's open meeting stuff, but we can do it that way, and I can inform a new draft. Were you done? And then I have Mr. Weddleton.
Oh, yes, I have another section I'd like to add here, so.
Can you just describe it so we stay on the same page, but we won't argue a whole bunch about it? But
No,
yeah, go ahead and
let's wait
describe
till
it.
we finish the conversation about this section and then
I
another point.
think that was most of it. Are we
Then
done with
Mr.
that
Weddleton
section?
had one.
No, mine's more processed.
Oh,
I
okay.
can live with the 5 years.
Okay.
So,
One vote for 5 years. Yeah, what's the D?
I would like, unless I'm misinterpreting what it does, I would like to recommend removing section 6 of SB 54. So, it looks like what they're doing here, and we need to have a long conversation about this, Eric, but it looks like what they're doing here is going from 18 months of possible suspended time to up to 1 year of active time. And as you know, there's a huge difference between suspended and active time. And I think it's relatively rare that in these first-time offenses they give 1 full year of active time. But it just doesn't seem, again, unless I'm misreading this, it seems like we're going to a system that is harsher than what existed prior to SB 91. And even if that's not the case, we're going to a system that seems harsher than is practical. So I would like to see either it removed or us to have a much more significant conversation about Section 6, because I'm not, looking at SB 54, that is the section I think I'm most uncomfortable
Okay,
with.
let's just get a response. So again, so we're on the same page. What is Section 6?
So
And
Section 6 is referring to Class C felonies, and SB 91 changed the sentencing scheme and lowered it so that on your first-time C felony, you could not serve any active jail time.
C felony.
C felonies.
We don't use
And
the
what
felonies
this does is attempts to restore the ability to impose some jail time. The year is less than what existed before SB 91, so that I believe was a compromise. If I may give an example of the, I'll say, absurdity of not having jail time on a C felony. Recidivist assault, your third assault in 5 years, is a C felony. So at our stage, you could get up to 365 days in jail for your first and your second. When you get to your third, and we actually get the state to charge, now you get all suspended time.
Up, up, down. Okay, I'm sorry, did Mr. Traney or Mr. Peterson have a comment on that? So it's not a no, but it's a think about it on what you're saying. So you two can get together, or we can address it in the next work session. Yeah, appreciate that. I think you had more of a process. I'm sorry, go ahead.
Well, 2 points. One is we could go through this, but Seneca, if you just sent these things into the people in the legislature working on this and said, hey, I'm the municipal prosecutor and I think this, do they just ignore you and it has more talk coming from us?
I think it would be very valuable to hear from the Anchorage Assembly what Anchorage wants.
Okay. And second, are we allowed to send everything there? What's our rule?
Yes, I think you and I can have a conversation about this. I can't have that same conversation and include more than 3 people, nor can I say, well, John said this. But you sending me and us back in an open session saying I've revised it based on, they wanted to prohibit serial conversations, not parallel.
That's a lawyer's interpretation. What's our part of it?
We've had a discussion.
You asked.
We've had a discussion at a work session, and he's just compiling and putting out a second edition. Okay.
But,
And
but
then
if
we
you,
will have an open meeting.
but if people don't feel comfortable, then they can keep a bunch of notes and bring it up at the next work session, and that works as well too. Did you have more?
Just as the statement made, though, it means that could apply to us, but not them.
It is kind of strange, isn't it? Ma'am, is she still here? Or we've worn her out? I apologize. She testified at the homelessness committee. Maybe I should have brought her first too. I'd just like to very briefly say that Senators Coghill and Ellis, who were the first two sponsors on this bill, I have continue to have tremendous respect for. They're two of the most just sincerely ethical and always doing what they believe is in the public best interest. The difficulties that I cited with this are, I think, some in lack of coordination, that is, other entities didn't get on board, some in sort of the data that was used, some in the theory of getting rid of a stick when you're haven't got the carrot all fully developed, but none of it on either the overall intention to try and shift to treatment, or their or any other sponsors' lack of goodwill on it. I think they all had. And we identified just on the fly 5 or 6 things that made this a bad combination. We were doing it at the time. We were cutting treatment funding and cutting police officers and all those things. So it was an appropriate thing to try. I think already, from my experience as a prosecutor and knowing what they do, they already try and use suspended time for non-violent people to get into treatment who have substance abuse issues or other issues. So that aspect was already there. But emphasizing it and pushing it is still appropriate. But it's also appropriate. Senator Ellis said in the paper we shouldn't do a major overhaul of it without due consideration. I'd like to do a minor overhaul of it with due consideration, and I think that is appropriate. We've worn out our only public witness. Anyone else come in that wanted to say something from the public? We'll have her back from the Rogers Park Community Council. She will be, I have no doubt. Everyone needs to speak up. Thank you for your time, and yeah, we will have another work session on this resolution before it comes out. Anything else?
And also on the holiday email that we all received.
Oh, so we all received an email from a representative of Holiday gas stations, convenience stores, anyway, from Holiday, about being assessed for reporting criminal activity in their area. When Senator Guess and I worked on the bill that gave authority for municipalities to charge for frequent users of their services. We were thinking more hotels who rented to bad people and didn't monitor it, and to some extent renting to people who then had a drug dealership in their place. And so I've committed to have them before us, to have a work session of the Public Safety Committee on that and try and fix that problem. We didn't mean to include legitimate businesses who were complaining about criminal activity or helping people report criminal activity. We meant more people who were facilitating it, and so we'll try and get to that. Yeah.
I have some information on that if you want it now.
Yeah, absolutely.
And I'll be real brief because I know we're at the very end. But I saw that letter. It's a reference to the 2 holiday stations. I looked into it briefly with Lieutenant Carson, who's in charge of the CAP team, who does all of that, sending notices out and so forth. The notices, when they go out, they don't include reports of legitimate criminal activity. When the ordinance was crafted, it very specifically sort of categorizes what things do get counted in that list and what things don't, and we've been adhering to that. So with respect to those 2 locations, it's all of the sort of nuisance calls that were included in the original 880. And every single time we send out a notice, it says in the notice, if you're willing to work with us, the police department, to resolve these issues, then we zero that out and you start over. And so we have not gotten that response back from Holiday Station stores.
So do you think it's a needed change in the ordinance, or the ordinance seems structured right and you just have to work with? All right, we don't necessarily have to have a meeting if you resolve it, but if you don't, we
I
can't.
remember we passed the ordinance here, and many times it's because these gas stations also have a liquor store associated with them. And the problem is, we get the calls from the product they're selling there at the liquor store.
Okay, so if you can resolve it, that would be great.
I again, and those are the only 2 gas stations in the city that received a notice.
Any other business to come before the committee? Thank you to our guests. We are adjourned.